Good afternoon, everyone. Thanks for joining us today for our webinar about the Independent Dispute Resolution Program. We'll cover the background goals and application of the IDR program. We'll also give instructions about using the IDR portal. After that, we'll take your questions during a live Q&A session. To get credit for today's session, be sure to stay online for the entire hour, including the Q&A at the end. You'll see a survey after we're done. Let us know what you thought about our webinar. All right, let's start the presentation, and I'll see you back here for the Q&A.
Good afternoon. My name is Marcus Wilcox. I'm manager in the Consumer Protection Division, and welcome to our IDR webinar. All right, we'll talk a little bit about the background of the independent dispute resolution process here in Texas. Senate Bill 1264 was passed by the legislature in 2019, and the IDR process went into effect on January 1st of 2020. And it protects consumers, prohibits providers from balance billing, and requires health plan to give notice of balance billing prohibitions. So it removed consumers from the process of having to dispute surprise bills for out-of-network emergency care. Before January 1st of 2020, most of the life and health complaints received by our consumer protection group were from consumers seeking to mediate surprise bills. They'd gone for some kind of out-of-network emergency care, received a surprise bill, and were contacting us for assistance. With the IDR rule being passed, the IDR law being passed, it took consumers out of that process, and now the providers and the health plan handle the dispute. So it created two processes to resolve the dispute. One, mediation, which is for facilities, and then the arbitration process, which is for providers for professional services. The IDR process applies to fully insured group and individual plans regulated by the state of Texas. In Texas, 17 to 20% of health plans are regulated by the Texas Department of Insurance. And those plans will have TDI or DOI on the ID card. Also covered under the IDR process are the Employee Retirement System of Texas, ERS, and the Teacher Retirement System of Texas, which is TRS. And then self-funded plans regulated through ERISA that have chosen to opt in. And they became eligible in 2023. And ERISA plans that have opted in will have TXI on the insurance ID card. Nonprofit agricultural organizations and higher education issue plans are also eligible for IDR in the state of Texas. The type of claims that are eligible for IDR are out-of-network services or supplies provided for emergency care, any type of planned professional services received at an in-network facility, and lab or imaging services provided in connection with in-network care. So these type of services would have to be referred by an in-network provider to an out-of-network lab or imaging provider. So the goals of the IDR program are to make sure that all parties comply with SB 1264. That's all the stakeholders involved. So the submitter, the health plan, the facilitators, any party that is involved in the IDR process, we make sure that they comply with all the statutes and rules. We educate health plans, providers, mediators, arbitrators. We've had training provided by us to various entities to try to make the process as smooth, as simple as possible. We administer the IDR portal. We work with a group of developers here at TDI. They created the portal. They've done various updates to the portal. They make sure that the portal stays secure through any type of patches or any kind of security updates that are necessary. And we provide customer service to all participants. We have a small team of people who are very good at what they do. They take phone calls. They handle emails. They review ineligible requests that are entered in by health plans. We also address any type of compliance concerns. We work with other regulatory agencies like Health and Human Services, who regulate facilities, and the Texas Medical Board, which regulates doctors, to make sure those parties are being compliant with any rules and regulations when it comes to the IDR process. We also maintain the commissioner's list of approved mediators and arbitrators, and we collect and analyze data. The data that we collect is shared with the Legislative Budget Board, members of the legislature, and various stakeholders that are involved in the IDR process. So as I mentioned, in 2023, the legislature passed a law that allowed ERISA plans to opt in. And as I mentioned, any ERISA plan that opts in would have the letters TXI on the ID card, which makes it easier to identify that it is a plan that has opted into the Texas IDR process. Plans can opt in 1 year at a time, and the plans that have chosen to opt it in are listed on our website. You can go to the balance billing portion of the TDI website, and it'll show you the information for the plans. It'll list, the administrator for the plan. It'll list contact information, as well as the date range that the plan has opted in for. So we'll take a quick look at the arbitration process first and the timeline around that process. An arbitration request can be submitted 20 days after the provider receives the initial claim payment and up to 90 days after that initial payment is made. The first 30 days that the request has been submitted is the informal settlement period. Parties can work together to settle the request. They can make offers back and forth. If they can't reach an agreement, they can select an arbitrator. And if they do select an arbitrator, that arbitrator will be assigned. On day 31, if no arbitrator has been assigned and if an agreement hasn't been reached, the request then assigns to an arbitrator. That arbitrator will then review the documentation provided by the parties and issue a binding award decision by day 51. Looking at mediation, that process is very similar. A request can be submitted 20 days after a out-of-network facility first receives a claim payment, and they have up to 180 days to do so. Again, just like with arbitration, the first 30 days is the informal settlement period. Again, parties can work together to settle, or they can select a mediator. Just like with arbitration, if they haven't settled or they haven't selected a mediator by day 31, the TDI portal then assigns a mediator. After the mediator is assigned, they have until day 180 to host the conference and work to get the request settled. They provide TDI with a report updating whether the request was settled or not, and the parties can then move forward with the process. So just a quick review. During the first 30 days, the timelines are the same. The request is submitted. The parties work to try to settle the request or select a mediator or arbitrator. If the request isn't settled and a median arbitrator is not selected, the case is assigned by TDI, and then the arbitration is completed by day 51, and the mediation is completed by day 180. The providers or the representative log into the IDR portal and start the process of entering the request after 120 days of having received their first claim payment. It's a real simple process. It's very user-friendly. Once the provider starts the process of entering the request, they can monitor their request every step of the way, and they can always go back and view old requests. So from the time they enter a request, that information is always available for them to see. In an effort to make it as simple as possible, we just collect very basic information such as the claim number, the patient's name, the group policy number and the plan ID. We ask that providers go through and verify that the patient's plan is eligible. A way they can do that, again, is looking at the ID card, looking for the TDI or DOI, which is a good indication that it'll be eligible. If they are ERS or TRS plan members, again, that is a good indication that the plan will be eligible. Or if it has the TXI listed, which indicates that it is a plan that has opted in. It's an ERISA plan that has decided to opt in to the Texas IDR process. The portal asks basic questions. It walks the submitter through it. And once the request is submitted, the health plan is notified that they have a request, and then they can view and update the request accordingly. So this is an example of the first thing the health plan sees. We ask that the health plan update any type of details that will make the process more accurate. So we ask that they verify that the submitter has entered their NAIC number in correctly. If not, we ask the plan to update it accordingly. We also ask the plan to verify what type of health plan that it is. And of course, we ask that the health plan verify that they agree that it is eligible for the IDR process. Some health plans have provided us a list of self-funded plan group numbers. We've entered those into the portal, and an error message will appear if a self-funded group number is entered. We've done that in an effort to make it easier for submitters. Plans are constantly updating these numbers. In some cases, they are themselves going in there manually updating it. In some cases, they're just sending us batches of numbers, which are then entered in by our developers. Either way, we found that this is a very accurate process. So if you are a submitter and you're entering information into the portal and you get this error message saying that the claim is ineligible for the Texas IDR process because it's not a regulated plan, then you can trust that that information is accurate. If you feel it's not, you can definitely contact the plan directly or ask the IDR group to research it, and we'll do what we can to verify the accuracy of the information. Again, ultimately, the health plan would have to verify if that information is accurate or not. So the health plan is also responsible for entering the informal settlement period information. So the plan goes in, updates the date of the informal teleconference. They let us know whether the dispute was settled or not. They also update the amount of the dispute. And if there was a settlement reached, they update the amount paid, the date the payment was made, and the method of payment. We also ask for a payment reference ID. And this is just if there's any kind of dispute, if the submitter is saying that they didn't receive the payment, it makes it easier for all parties involved, the submitter, TDI, and the health plan, to figure out what occurred with the payment and to make sure that the submitter ultimately receives their payment. As I mentioned earlier, if no settlement is reached during the informal teleconference period, the parties can either select a mediator to be assigned to the request, or they can allow the system to do it. If they allow the system to do it, the 5 facilitators that are originally assigned to the request, one of those 5 will be assigned to the request. The parties have the option of striking 2 facilitators each. And if they do so, the parties cannot see who was struck by the other party. So in some cases, all 4 facilitators may be struck, and the system then assigns the remaining facilitator. In some cases, no facilitators are struck, and the system chooses one of the 5 facilitators and assigns them to the request. So if a facilitator is assigned, this is what they see in the portal. On the left side, you see what an arbitrator sees, and arbitration is a baseball style arbitration. So arbitrators use a position statement that is provided by the parties, along with 10 factors to determine the reasonable amount. They then determine the binding award based on the closest final offer. So as you can see, they enter the date that they completed the arbitration. They enter the final offers by both the parties, and then they put in their reasonable amount and then close their portion of the request. The parties are then notified that the arbitrator has completed the request, and it moves forward accordingly. With mediators, it's very similar. They enter the information as far as when the mediation session occurred. They also enter if a settlement was able to be reached. And if no settlement was reached, they have the option of entering the reason for the impasse. They don't have to enter the reason, but it is something that they can certainly do. The last thing that happens is health plans then go in and enter payment information, which they do within 30 days. As you can see here, the information is virtually identical for both mediation and arbitration requests. Again, we ask the health plans to enter the amount paid, a reference ID, which makes it easier to track in case there is any kind of dispute. They also enter in whether they've paid the arbitrator and how they paid the arbitrator. Again, the goal is to make the process as simple as possible. And if there's any kind of dispute about a missing payment, it makes it easier for all parties to track that payment. So as I mentioned earlier, we do collect data, and I'll spend a little bit of time talking about what we do with the data and then sharing some of the data that we collect. By law, we have to issue a biennial report. We also have to collect quarterly data from health plans and their administrators. We conduct studies on the impact that the bill is having on Texas consumers. Again, the impact that we're seeing, that it's a positive impact. Consumers are no longer having to participate in the mediation process, which we find consumers appreciate. They like the fact that any kind of claim disputes that are occurring between the health plan and the provider. The data in the biennial report is presented by calendar year. So the most recent biennial report that we have is for 2024, and it includes data from the start of the program in 2020 through 2023. So looking at some of the data that we've seen over the past almost 6 years, as you can see, initially, the vast majority of the requests that were entered were for arbitration. In 2020, they were almost all arbitration requests early on. And then as you can see, more and more mediation requests have been entered into the portal as we move forward. So as you can see, for 2025, the majority of requests entered into the portal are for mediation. We saw a big increase in September, and we believe this is due to the bill that was passed by the legislature in 2025, where all claims pre-6/20 of 2025 must be submitted into the portal by 10/20 of 25 to be eligible for the Texas IDR process. For September of 2025, almost 57,000 mediation requests were entered into the portal, which is the most that we've ever had in 1 month. To put this in perspective, when the IDR bill was being discussed by the legislature, some testimony that was given as far as estimates for IDR requests in a year was 30,000. So for the month of September, we've had almost double the mediation requests that were initially anticipated for total IDR requests for a year. And as you can see from this slide, even the first year where there were hardly any mediation requests, we exceeded the expected goal of 30,000 total IDR requests, and the number's only been increasing since then. If you look at the data for 2025, which runs through October 7th, we are almost where we were for 2024. So we fully expect to exceed the 2024 total by November. So I wanted to share a little bit of data that we have regarding the types of requests that we're receiving. For arbitration requests, the vast majority of the requests are from ER doctors, which makes total sense since the program focuses on out-of-network emergency care. Again, sharing a little bit more data about mediations. The vast majority of the mediations are freestanding emergency rooms. And then here's a little bit of information that shows the outcomes of the requests. So the majority of both mediation and arbitration requests do settle during the first 30 days. Parties are able to reach a settlement, to find a amount that they consider acceptable, and the request is then closed. From an arbitration standpoint, roughly 83% of requests settle informally. This includes during the 30-day period, or if they are assigned to a facilitator, that facilitator can then still mark them settled informally if the parties reach an agreement after the request has been assigned. With mediation, very similar. The majority, 83% in this case, settle informally. And that can be, again, during the first 30 days or after the facilitator is assigned. Just like with arbitration, the mediator has the option to mark the request settled outside if the parties settle prior to the mediation. If you have any questions, you can visit our balance billing independent dispute resolution page on our website, or you can email any questions to idr@tdi.texas.gov, and they'll be answered by the IDR group. And now for the Q&A portion of our webinar, where we'll answer any of your questions.
All right. Joining us today to answer your questions is Marcus Wilcox. We also have Bob Simons. Bob is the director of the Office of Policy Development Counsel in our General Counsel Division. All right, just a couple ground rules before we get started. We're not going to answer any questions about a particular company or situation you're having. You can email questions if you have more to idr@tdi.texas.gov. We'll also put that email in the chat, and I'll repeat it again before we leave. To ask a question, use the Q&A button at the bottom of your Zoom window. We'll try to respond to as many questions as we can. And if we don't get to your question today, you can email us and we'll try to get you an answer. All right, let's get started with some questions. First one up. TDI isn't taking applications presently for mediators or arbitrators. How else can you get to this kind of business?
Yeah, I'm sure that Marcus will get to here in a little bit. I think there's quite a few questions about when the mediator and arbitrator lists will open, but I would say the mediation process in particular is flexible and kind of depends on facilities and plans working together. So it is entirely possible on the mediation side to have both parties, essentially both the plan and the facility, agree to use a mediator. They don't have to be on our list. In fact, we love it when plans and facilities work together and figure out how they want to mediate that particular plan or how they want to go through IDR. So by all means, I don't know how you would get your name out there, but to the extent possible that things get done and taken care of kind of somewhat outside the IDR process, we are enthusiastic supporters of.
Okay, well, let's get to that question. Marcus, when will you reopen the arbitration application process?
The short answer is I don't know. We review the data all the time. We're always looking at, do we need more mediators? Do we need more arbitrators? So that's something that Bob and I and several other parties talk about. So we're looking at it all the time, but I don't have an answer for when that'll happen. I always suggest on our website, there's a link where you can sign up for any type of notifications. So if you go there and sign up, if you're interested in being an arbitrator or mediator, just sign up there and you'll receive notification from us when the application process does open.
Okay, sounds great. All right, our next question. Are there any plans to enhance the dashboard from a provider's perspective? An example, it would be nice to see and export ineligible reasons, mediator names, things like that. Would it be an issue to see how much a provider owes one specific mediator?
So we haven't had any plans to enhance the dashboard in that way. We're always open to suggestions. We're always looking at making some improvement. We're kind of limited on what some of the things that we can do. The IDR portal sits on a shell, kind of the best way to describe it. So our developers don't have complete control over what changes that we can make. But we are always looking at enhancements. As far as what someone owes a mediator, that's not something that we would keep track of. So at this time, that's definitely not a part of any type of enhancement process. But if you have any suggestions, definitely send them to the IDR team. We do have an area where we store suggestions, and it's something that we review regularly.
Okay, great. What happens to the plan if they opt in? Why wouldn't a plan want to opt in?
I'm guessing this has to do with the ERISA opt-in procedures, and that was added after 2019. I think, correct me if I'm wrong, Marcus, was that 2023 when that option was added? So,
Yes.
if Texas IDR process is not available, then the federal No Surprises Act, which came after our process, and I think in the shadows a little bit, in the footsteps of. So then the federal process would be involved. That is kind of up to those carriers who are offering those kind of ERISA plans as to whether they want to opt in or opt out. I know that some have. I don't have the numbers at the tip of my fingers, but I know that some have. And if they do, and I think Marcus, I think the presentations mention what the card says. Is that correct, Marcus?
Yeah, it'll say TXI on the card. The only time that designation should appear on an ID card if a plan is opted in to the Texas IDR process.
And there are definitely differences between the federal process and the state process, and so someone might prefer one or the other. I think it's kind of up to their subjective reality as to what they think makes more sense. So why plans would do it, it's really up to them.
Okay, we'll move on to our next question. What should neutrals do when the case is closed, but the parties have yet to pay and the case is about to meet the deadline?
Yeah, definitely reach out, ask them, why they haven't paid, make sure they received your invoice or, however it is that you've attempted to get that payment. If you haven't, if you reach out to them, you still don't receive the payment, please let us know. We'll do the best that we can to try to make sure that, an entity pays. If it's on the facility side, again, as I mentioned in the presentation that I felt was super cringeworthy, we'll work with Health and Human Services and TMB to make sure that you get paid. Again, we can't enforce a payment per se. So, we do let people know, hey, if someone owes you some money, you can take any action that's legal to collect that payment, but we'll do whatever we can to make sure that you get paid the money that you owed for the work that you did.
Yeah. And we're in regular communication with those other state regulators, so HHSC and the medical board and whatnot. And I'm a lawyer. I like to look to statutes. So one thing to always keep in mind is 1467-004 says the remedies provided by this chapter are in addition to any other defense, remedy, or procedure provided by law, including the common law. So, you've got the full gamut of options if things break down. But by all means, file a complaint with us, and we can also get in touch with our other fellow state regulators.
Okay. Our next question is, I'm both a mediator and an LPC. As an LPC who is a provider in network with several insurance companies, is that a conflict that prevent me from mediating with TDI?
I'll let Bob address that as the attorney.
Yeah, I guess so. I was looking at our FAQ to see if it addresses it. I know our FAQ mentions what is considered a conflict. I hesitate to say so with a grain of salt. I don't think you are categorically barred from being a mediator. You definitely couldn't be a mediator on that particular for those plans that you might be working with. Does that sound right, Marcus, or am I off base?
No, it definitely couldn't be the one for the plans that you're working with. So that would make it challenging, right? Because as we discussed, the system randomly assigns, and we don't have a way to say, this particular person can't, do a request for X plan. So that would make it challenging, and it's something that we'd have to look into, but it would most likely preclude you from being a mediator or arbitrator, just because of the system limitations.
Okay. All right. Next question. Are the day deadlines listed work days or calendar days?
So they are calendar days. I do have to say that there is an exception. So a deadline in the state of Texas cannot be on a holiday or a weekend. So if an arbitrator has, as I mentioned, 51 days, if that 51st day falls on a weekend or a holiday, then you wouldn't receive your decision until the following day. But they are calendar days, again, exception being weekend or a holiday.
Yeah. And that is we get this question on all sorts of rules and all sorts of processes. And so that is kind of straight out of Government Code 311, how to compute days. And so as Marcus said, exactly right. If it falls on a weekend or a holiday, it rolls to the next day.
Okay, great. Okay, what happens after the case has been assigned to a mediator, but the parties settle on their own? One of the parties contact our office. Should we submit a report without any documentation?
So the first thing, please always check with both parties that they agree that the request is settled. We have seen situations where a mediator was notified that, hey, we settled this, and then the other party does not agree that it was settled, which makes things challenging. So please verify with both parties that they are in agreement that it's settled. And if that's the case, there is an option to mark it settled outside of mediation. It's just a little radio button. You click on it, and then that you're done.
Okay. All right, we're finding many cases have the incorrect amounts entered into the portal. Therefore, the payments we receive are incorrect. What can we do when this happens?
That's an interesting question. Right, no one's perfect. There are definitely going to be, mistakes. If you find that there's an incorrect amount entered, please address that in your position statement. Please let the facilitator know, hey, this is not the correct amount, and then let us know as well. We'll look into it. Again, mistakes do happen, and we'll do the best that we can to address it up front and make sure that you receive the correct payment that you're supposed to receive. But please, again, let everyone know, let the facilitator know, let us know, and we'll do what we can to make sure that gets sorted out.
Okay, great. Is there a minimum required amount of claim by the provider and or the receiving party of the service to be accepted and processed in the IDR?
No. I mean, the thing I would say is, make sure if you're entering a claim that's going to potentially assign to someone, make sure that it's worth it, right? Because if you're paying a fee to a facilitator and you're paying the facilitator more than the claim is worth, that's probably not a great business practice and not something I would enter into the portal. But there's nothing in the portal that's going to stop you. I mean, you can put in a claim for $1, but again, it's not going to be something that's worth your time or money, in my opinion, anyway.
And this is probably one thing where the difference between Texas law and the federal NSA probably matters. So in the federal NSA, when something has been settled, I think there's not an expert on it, I think there's a 6-month period where eventually basically that number is kind of locked in. So future inquiries or future IDR requests related to the same facts, you're going to be stuck with that number for a while. And maybe in those scenarios, it might make sense to get a final mediation result, even if the amount in dispute is less than, your 50% of the mediator or arbitrator fee, because then, maybe that matters down the 6 months down the road. But that is a difference between the state and the federal process. Ours does not have that.
Okay. Speaking of money, how are mediators paid?
The mediators are paid by the parties, right? So both the parties split the mediator's fee or the arbitrator's fee, the facilitator's fee, and each pays their half, and it's due upon assignment.
Okay.
Yeah, and I will say that, back in 2019 when we were drafting these rules and kind of that initial big legislation, it's been tinkered with, I think, every session since. There was a lot of thought about how the process was going to work in terms of nuts and bolts and when the mediator and when the arbitrator were going to be assigned. And it is baked into the process and baked into the rules that they are assigned automatically, on the 31st day. And that is by design. That is so that there's an incentive for plans and facilities or providers to do their own informal settlement ASAP. Otherwise, they are going to be on the hook. And also, candidly, that protects the mediator and arbitrator from, doing a lot of homework for something that then, like Lucy in the football, right, that eventually handles it. So that is an incentive to do informal settlement. And I think we've said in other insurers before, please avail yourself of the ability to informally settle things before the mediator or arbitrator is assigned. I think that that's probably the best possible outcome anytime we have some of these independent dispute resolution requests.
Okay. Okay, another one about money. Some facilities complain about the mediator fee. Is there a suggested fee mediators should charge?
No, there's nothing in rule and statute regarding the mediator or arbitrator fee. Those fees are set by that individual. They're available to see on our website, but we do not have any input on how fees are set.
Yeah, at this point, we have not attempted to, set ceilings on any of those fees. I will say, I think, Marcus, isn't it true that this fee is going to be in the bio or in some kind of information so that participants can see what the fee is, particularly in mediation where you may agree on a particular mediator. Maybe that's information that participants want to take into account as they go through this process. And in the arbitration, when maybe there's those participants are looking at the list of potential arbitrators. Is it five that are assigned initially? Possible? Is that how that works, Marcus?
Right.
Did
Yeah.
they see that as well?
Yes.
Yeah.
Yes.
So if one of those fees is deemed by the participants, too much, then take advantage of the process. And I think it's sort of can kind of work itself out that way.
Okay. Our next question is, when first supporting TDI, do ADR professionals have to serve as a mediator first before serving as an arbitrator?
No. So we do have some facilitators that are both mediators and arbitrators, but we don't have a rule that says you have to be one before you can be the other. So, again, at some point, we will open the list back up. You can apply for a mediator, you can apply to be an arbitrator or both, but you don't have to be one before the other. Again, we'll ask for your CV, just kind of, a general application, just complete the process, but you don't have to be one before the other.
Okay. When does the clock start for the IDR process? When the claim number is assigned, or is it another trigger?
No, there's no additional trigger. So once the submitter, enters all the information and the request number is generated, the clock starts right then and there. Again, 51 days to the end of arbitration, 180 to the end of mediation, and that starts as soon as that request number is generated, which is instant.
Okay. And what's the URL of the website you talked about for sign up? Is that just the general TDI website?
Yeah, it's the TDI website. It's
Okay.
under balance billing. We can get that information and put it in the chat.
Okay. All right. For parties who elect mediation arbitration, what timeline applies? 51 days or 180?
Both. For arbitration, it is 51, and for mediation, it is 180. So it just depends on which type of request that it is.
Okay. Will you provide arbitrator mediator training if TDI decides to open the applications again?
Absolutely. We'll make sure that last time we recorded a webinar for folks that weren't able to attend, and we'll do the exact same thing this time. We'll make sure that people are able to log into the portal, navigate the portal, and we'll go from there.
Okay. Our next question is, let's see. Are there any plans to add fields to the exports for active request? It'd be helpful to be able to export claim number, member information, and request party details.
No, it's not something that we've looked at right now, but it's certainly something that we can do. Again, I can't guarantee that it's possible, but we can certainly look at it, and I'll be happy to discuss it with the developers that we work with to see if that's something that we can incorporate. Again, we're kind of limited on what we can and can't do, but it doesn't hurt to ask.
Okay. All right, our next question is, are there any requirements for a payer to actively participate in good faith during the mediation? We have some payers who will not offer any more than the informal settlement amount.
So this is interesting, and I'll ask Bob to chime in on this as well. So there's nothing in rule or statute that says how the negotiation has to take place, right? It just says that someone with the ability to negotiate has to be present at the meeting, right? I've heard people say, if someone says they can only go up to a certain dollar amount, they feel that is not, that they don't have complete authority to negotiate. But unfortunately, like it's not defined in rule or statute. So as long as someone is there at the meeting that has the ability to do some sort of negotiation, that's all that the rule and statute talks about.
Yeah, I think that's right. It's a slippery concept of trying to, read minds. So we haven't really gotten in too deep. It's something we are aware of and definitely see complaints on. So feel free to, continue providing your opinion. When it comes to the informal settlement period and when it comes to mediation, I mean, I think the model is that the two sides agree. So I can't force people to agree. And that's definitely part of it. So, but I think everything Marcus said was right. Yeah.
Okay. Our next question is, with the new mediation submission window that applies beginning on October 21st, does that mean that any dates of service before June 20th aren't eligible, regardless of when the claim was processed or paid?
Yes. So that was outlined in a bill that was passed. So we made sure we updated that information to the portal as soon as possible. But yeah, so if you right now try to enter in a claim that has a date of service of, I don't know, 1/1 of 23, you will get an error message saying that it's not eligible for the Texas IDR process.
And there are, of course, outside of IDR, there are various, prompt payment and other kind of requirements, trade practices that are required by carriers and plans in order to adjudicate claims promptly. So it's very possible that some of those claims, if they've been sitting around far too long and they had all the information that was necessary, that there may be other statute or other rules that come into play.
Okay. All right, our next question. Is it okay to send one bill for numerous requests to one facility, or should all requests receive an individual bill?
Again, that's not something that's addressed in rule and statute. If you're willing to send one bill and if the facility is willing to, pay just off of one bill, we definitely don't have a problem with that. I know I've seen cases where, both parties say that they need an individual invoice for each request in order to be able to pay. So, whatever the practices are of that entity, the payment practices, different entities have different rules regarding payments from their accounting standpoint and things like that. So we really don't have any input on that. As long as the parties are okay with only receiving one email or invoice for numerous requests, we don't have any input on that at all.
Okay. All right, our next one is, do you have any tools to ensure that the facilitator is objective and not siding with one side or the other?
So we do review the data, right? We review how we compare how different arbitrators and mediators are handling requests. So, there's going to be variances, but we're just kind of looking to make sure that, if there are any outliers, we take a look at that. So, that's kind of the tool that we have available to us to kind of see, where everybody falls. Obviously, if there was an arbitrator that 100% sided with one party or another, we definitely have some concerns there, and we'd have a conversation with that individual. So that is something that the IDR team looks at a regular basis.
And I think feel free to reach out to Marcus's staff and register your complaint and give us your opinion. We understand that the mediators and arbitrators are maybe the most important part of this process, and so we do want to make sure that their conduct is ethical and within the bounds of the statute and rules. And so let us know if we are not in those informal settlement conferences. We are not in with the mediation, in with the arbitration. We're not seeing the messages back and forth. It's simply so voluminous. We just don't have enough time to be actively involved. But reach out. We want to make sure that all parties trust the process. That's important to us. So if there is something that is undermining that trust, let us know.
Great, for sure. Okay. What about if an arbitrator enters an incorrect amount?
This is a challenging situation for us, and it does happen. Again, no one's perfect, right? But the way the statute's written, and again, I'll let Bob, chime in on this as well. But we don't have the authority to make any kind of change to that, right? It's a binding amount. So once the arbitrator enters that amount and they issue their report, we can't change that. So the remedy for that in statute is that legal action has to be taken. So it does kind of take it out of TDI's hands where, if the arbitrator makes an error, even if they acknowledge that they made an error, it's binding and we cannot change that.
Yeah, and there have been, with the million or so requests, I feel like the rules work for 99.999% of things, but that still means plenty of oddball scenarios are going to occur. So we do our best to try to find fixes, but ultimately we are bound by the statute and rules, so we do what we can. I will say that there have been a handful of suits that have gone to district court. So there are people who since 2020, I guess 2020, right, when it really became effective, have gone to district court to overturn arbitration decision. I can think of at least a few that were successful in that, and then we ended up putting them back through the system. So the law contemplates the ability to review arbitration decisions.
Okay. Our next question is, how's the fee structured? If you settle, are you still compensated?
Yes, the payment is due upon assignment. So, let's say Bob and I are in negotiation. We agree on amount on day 33, but the request is already assigned to a mediator. We are both responsible for our half of that mediator's fee. And again, the mediator can go into that request, mark it settled outside of mediation, and move on to the next request.
Yeah, and again, that was by design. That's a fairly harsh rule. We assign it, the payment is due immediately, and that is baked into the rule. And that was kind of a design decision that was made when implementing the statute back in 2019, starting 2020. That is to encourage communication. Sometimes life is like high school and people have a tendency to wait to midnight before they work on their term papers. But, I encourage facilities, providers, plans, start reaching out well before those deadlines so that if you can reach an informal settlement, there is enough time. You want to do that. You want to get it entered in the portal, come to that agreement so that you guys are not on the hook for splitting the mediator or arbitrator fee.
Okay. All right. Our next one is, how's TDI enforcing mediation deadlines? If a particular party has issued scheduling, why should a submitter extend the deadlines?
So we're not telling anybody to enforce deadlines, right? Again, statute says that's up to both parties. If a party wants to grant an extension, or if a party doesn't grant an extension, we don't have any say on that, right? So the way we enforce that is we will address it based on who the responsible party is. So again, if there's a mediation session scheduled for day 179, if the health plan doesn't show up, we'll address it. If it's, the facility doesn't show up, then I can work with HHSC. I work with their enforcement division there and, speak to them about addressing that with the facility. So again, it just depends on who's responsible. Same thing if the facilitator doesn't show, obviously that's something that, I can address directly. So it just depends on who's responsible for the, mediation not being completed in the 180 days.
And I would just urge parties to work together. And if there's a reasonable request for an extension, if that's within your purview to grant, I encourage you. As I said before, and we'll say again, we encourage early and often settlement of these things. And so Let's not let things go to IDR that could be settled in the informal settlement period before you guys are both on the hook for that arbitrator or mediator fee. And there are going to be situations where maybe extensions are reasonable to accommodate. We as TDI are not going to go twist arms and make sure that happens, but you guys are all professional adults, so handle yourselves accordingly.
All right. Okay, our next question. Have all the 57,000 claims submitted by the October deadline been assigned to neutrals?
No, because it hasn't been 30 days. So those are my kind of questions that I can give
All
easy
right.
answers.
That's easy. Okay, how do I know whether I've been selected or assigned as a facilitator?
So if again, if you're already on the list, if you're already receiving mediations and arbitrations from us, you'd receive an email saying, "Hey, you've been assigned to this particular request number," which would then give you the opportunity to reach out for to the responsible parties, the health plan representative, the facility representative. If you're not already on the list, if you're saying how would you be notified if you're selected, then again you'll receive an email saying you've been selected to be a mediator or arbitrator. Here's the training date. Here's a login for the portal, and we would go from there.
Okay, great. If a provider hasn't been able to successfully set a mediation date or has several no-shows past the mediation deadline, is the mediator able to close the case as such so the provider can move forward with the next steps?
No. So the mediator should not close a case, unless the actual session takes place. Kind of let us know again, who the party is, what's causing the issue, but do not close the case. And, let us know. Again, if you're scheduling things early enough, hopefully we can beat the 180-day deadline. But, if it goes past the 180-day deadline, we want to make sure that, we address it with the party that's responsible for the deadline being missed.
Okay. All right, let's see. Next one. I'm curious if Texas IDR will be extended to other types of medical insurance, such as dental insurance.
Well, that would be an issue for the next legislature. And as I'm fond of telling my colleagues here in General Counsel, pre-filing is only 375 days away or something like that. So, but I will say that since 2020, they've added nonprofit farm agricultural plans. They have added those higher education plans, and there's now ERISA opt-in. And I feel like I might even be missing something else, but there has kind of been a slow enlargement of the scope and applicability of these IDR processes, but that's ultimately a question for the folks down the street here at the Capitol building.
All right. Next question. If we don't receive the offers from the insurance in the time frame, what can we do for those cases, or what will IDR do?
So if no offers received within the initial 30 days, that would be a violation, right? So you let us know, hey, this particular health plan is not negotiating, is not providing offers, during the first 30 days. And it's something that we would be able to address.
Okay. Our next question. Some facilities reach out claiming the claim was accidentally assigned to mediation, so they shouldn't have to pay. I assume the HP would have to agree not to mediate it, so it can be marked as settled outside of mediation.
I guess accidentally is an interesting word. In my opinion, there isn't anything where the system says, "Whoops, I assigned it after day 28, instead of day 30." So it's always hard for me to speak to hypotheticals, but I would have to look at that individually. But if someone's telling you something accidentally assigned, I don't necessarily agree with that. So it's always up to a facilitator, how they move forward, whether they want to waive a fee, whether they choose to still charge a fee. Again, it's due upon assignment. So there isn't anything that says that once the request is signed, you can close it settled or whatever occurs later down the road. But the payment is due upon assignment, and then you can reach out to the parties, reach out to us, and we can figure out what that accidental assignment was. But again, ultimately, it's up to the facilitator what they want to do with that.
Okay. A couple questions left. Many health plans and providers don't respond to coordination of mediation timely. Could there be a way to allow for TDI portal to accept a mediator input for date and time proposal for the mediation, with the HB and the provider agreeing, declining, or suggesting a new time? Email's difficult, it seems. This would allow for a central location for everyone to look up cases.
It's something that we've discussed in the past, and we've kind of gone down the road of seeing what we can and can't do to update the portal, and we haven't been able to figure out how to exactly make that work through the portal within the limitations that we have. But it's something that we continue to look at. I'm not here to take anybody behind the woodshed. I'm not here to be the principal, but it is our job to make sure that this process works. So if someone is not responding, again, whether it's the health plan, we'll address it. If it's any of the other parties regulated through another state agency that we work with, I'll work with that state agency to make sure that that gets addressed. So if you're seeing that, don't suffer in silence. That's what I always tell everybody, right? Just send up a flag, reach out to the team, and we'll do our best to figure out what's going on with it. And if we can't, again, we will work with our partner agencies to get that situation resolved.
Okay. This next one is a suggestion. Could you put a button on the portal that addresses the problem of the decision being submitted before the deadline for payment has been reached?
Again, something challenging, something I can take back to our developers, seeing what they can and can't do. But again, it's something that I'm certainly happy to ask about. I can't, I tell people all the time, I'm a guy that went to school for history, so I don't understand all the ins and outs of what our developers can and can't do. It's all Greek to me. But all I can do is ask, and we can follow up on that.
Okay, great. All right. During informal settlement, what are the accepted ways of communicating or negotiating? Can it be resolved only through email?
I guess I can take that. Yeah,
go ahead, Bob. Sorry. No, I defer to the attorney.
Oh, yeah. Well, the statute says teleconference, and I guess we did not define teleconferences, but I guess also since around March 2020, we have all become very familiar with what exactly a teleconference looks like. So the statute and rules kind of contemplate a teleconference. I would say if on either the mediation side or the arbitration side, if everybody comes together magically via email and agrees to it, and it doesn't have to be assigned by a mediator and arbitrator, I think we are happy. We are happy in this building. So, but I think generally speaking, that the statute and rules contemplate that a teleconference is going to be how that informal settlement is going to exist.
Yeah, but again, as Bob said earlier, it's our hope that parties work together, right? So if if email works better, Zoom, whatever, right? If parties work together to make sure that that process happens, we, like I said, as long as it happens, we don't have an issue.
Okay. All right, we're going to wrap it up here because we're about out of time. If we didn't get to your question or you think of another one, you can email us at idr@tdi.texas.gov. And after we're done here, you're going to get a short survey. Let us know how we did, what you thought of our webinar. You also get a follow-up email in a few days with this recording and the slides and the Q&A session. All right, that's it for today. Thanks for joining us. Have a great rest of your day. And we'll see you at the next TDI InsureEd webinar.